Great. I think we've got about 3/4 of the RSVPs in, so I think that was a good time to start. So first off, good afternoon, everybody, and thank you so much for joining us this afternoon for GreenCape's webinar with the City of Cape Town. We're going to be addressing a very exciting topic with some panelists over the next hour, and we're going to be chatting about the potential outcomes of the City of Cape Town's legal challenge with regards to the process and rights to procure energy from independent power producers. The court case took place on the 11th and 12th of May, and we're joined by an exciting panel to chat us through what happened. So firstly, the Executive Director of Energy and Climate Change Directorate, Mr. Kadri Nasib, also the Director of Sustainable Energy Markets, Mrs. Leila Mohammed Bederman, and Energy and Climate Change Directorate Principal Professional Officer, Ms. Susan Mostel. Thank you so much for all of our panel members for joining us. We are really excited to be able to navigate through this topic. And with the amounts of signups that we've had, it's clear that industry are also really excited to get some feedback. In terms of a basic structure, we're going to kick us off just going through some of the core arguments that were made in the court case, looking through some evaluation and comments from those that were involved, mapping out a bit of the potential outcomes, either positive or negative, and then also looking at a way forward in both cases. At the end, we will do a short feedback or Q&A session. If you look on the right-hand side in the drop-down panel, there is a questions section where you can post questions, and we'll be taking 5 or 10 of those towards the end. Also, just a word, we are recording this session, so it will be available afterwards for everyone to look at that case. But without further ado, I'm going to hand over to Kadri to take us forward. Thank you so much, Kadri.
Jack, thank you so much, and good afternoon to everybody that's joined us on the webinar today, and also just to acknowledge my colleagues Leila and Sue that will be joining me during the presentation and also afterwards just to answer questions that you might have. And I think thanks just to GreenCape for arranging this particular session. I think it's a valuable one for industry. It's also a valuable one for metros other than just the City of Cape Town for obvious reasons. As you can imagine, and you'll see from the presentation, that we've been talking to national government for at least the past 4 to 5 years in anticipation of opening up the energy market in the City of Cape Town. And of course, this has been met with lots of interest, not only from other metros, but obviously from industry and IPPs in particular. And so we've reached a critical watershed moment in the energy landscape for metropolitan councils and even for the smaller municipalities in the country. So today's session is really designed to give you an update, first of all, on the court case itself as to how we think it transpired, and we don't want to preempt the judge's verdict, but just to give you some insights into how the arguments ran with respect to the various councils that presented on behalf of ourselves as well as the respondents. And also just to take you through a preliminary overview of what the outcomes mean for the city in particular and what that could look like in terms of process going forward. So Jack, if I could have the first slide, please. So I think first of all, just to understand, and the next slide, please, just in terms of the background to the case, and I've already mentioned that there has been engagement of some sorts within the energy sector within Cape Town for at least the past 4 to 5 years, talking about opening the market and in particular including a larger contribution from renewable energy into Cape Town's energy mix. And of course, that has since been included and incorporated into the integrated development plan for the city, and the current version has already adopted certain targets for renewable energy. So it was with this in mind that the former mayor approached its own legal advisor with a request to understand whether the city could proceed with an energy mix that contained renewable energy purchased from sources other than Eskom. And of course, the legal opinion was that this is possible, and in fact, we should proceed on that basis. And it was with this in mind that the mayor approached the then Minister of Energy, which was Minister Tina Joma-Peterson, in November of 2015 to obtain a determination in favor of the city under Section 34 of the Electricity Regulation Act, as it was. And of course, the idea was then to procure at least 400 megawatts of combined renewables, which would be predominantly solar and wind, from the open market. And this would have been the start of a process for us to meet the targets contained within the IDP for the city. The city only decided to go for, first of all, the legal case only because of a lack of response coming from not only the minister at the time, but also subsequent ministers have failed to engage on this particular matter. Now, while there's been some movement, and we'll talk about that movement towards the end of the presentation, there hasn't been a clear discussion taking place with the municipalities, and in particular the City of Cape Town, with respect to the rights and responsibilities that the city has in relation to the current legislation as well as the Constitution. So, of course, this has really kept the fire burning in terms of the court case and has prompted the actual hearing which took place, as Jack said, on the 11th and 12th of May. So a decision that was taken with the best interests of not only the city at heart, but also the other metropolitan councils that would benefit from such a decision being taken in the favor of the municipalities. Thanks. If I could have the next slide. One of the important considerations for us as the city is that we felt very strongly that Section 34 of the Electricity Regulation Act is being misinterpreted. It's empowering, and I'll talk about that again later, but it's certainly not peremptory. And the use of the word may is very strongly associated with this function. It does not indicate the words like must and shall, and therefore we feel that the interpretation of that has been misconstrued. So this will come out later in the course of the presentation. We did find also in our argument that we found that if the court believed that Section 34 was legitimate and in fact was prohibitive, that we found that that would be unconstitutional. And of course, we invoke our constitutional rights in that regard, and that has also been a matter that has been placed before the court. If, however, it was found by the court that the Section 34 was in fact constitutional and of course legally binding on us, then we asked in fact for the court for some relief in terms of the minister having to make a determination within a predetermined period of time. And of course, the idea was that these arguments would be supported by reference to the constitutional duties, in particular Section 156 of the Constitution that talks to the responsibilities and duties of these municipalities. So at the same time, by the way, we were joined in the case by an amicus curiae as a friend of the court, namely the Center for Environmental Rights, bringing a slightly different slant to the case. And they discussed more the elements around the environmental benefits of renewable energy and the need to consider issues like legislation like NEMA and how best to actually undertake an energy mix which was environmentally sound in terms of its compliance to legislation, but also taking into consideration the city's low carbon trajectory, the need for us to protect the environment and the constitutionality of that as well. Thanks. If I can move on to the next slide. Now, just to unpack some of the issues around the city's argument. And in the first instance, the Intergovernmental Relations Framework Act really tries to create a space for spheres of government to deal with disputes in a manner which takes it out of the legal domain. That is, of course, to respect, I think, the various roles within government and to avoid overlap and duplication in this regard. Now, in terms of the Intergovernmental Relations Framework Act, the city contends that our primary dispute is in fact with the regulator, not with the minister. And the reasons for that is that the regulator has, of course, denied IPPs their licenses. And at the same time, the regulator is not an organ of state. And in fact, it is meant to be an independent regulator. And therefore, the notion of a dispute with another organ of state does not enter into the equation. Also, and very important to note that there is no dispute currently with the Minister of Mineral Resources and Energy, mainly because there's been a failure to engage on the part of the minister. And under such circumstances, you cannot have a dispute when there is no engagement from the other party. And so therefore, it was felt very strongly by the city that one should proceed to the court to obtain clarification with respect to roles and responsibilities in the absence of a definitive response coming from the ministry. Thanks. If I can have the next slide. In addition to the Intergovernmental Relations Framework Act, the most important element of our argument relates to the interpretation of Section 34. Now, under Section 34, our senior counsel, Wim Trengove, unpacked essentially the language of that section, the purpose of it, the correlation with other planning tools and legislation, and then also looked at the sensible interpretation of that act, and then lastly, the constitutionality of that. And one thing comes through very clear is that certainly it comes through as if the section of the act is prohibitive when it is not supposed to be. I think it's common cause amongst the various council that that section of the act is enabling and empowering as it's meant to be, but clearly not meant to be prohibitive. And on no basis did the council for the respondents ever respond to the assertion from our council that in fact that section is prohibitive. So we've not been tested in respect of our argument that in fact it is prohibitive. With respect to the purpose, I've already alluded to the reference to the words may rather than must and shall. And that also obviously imparts to you the notion that the act, that section of the act was meant to be invoked in certain cases only, and predominantly in cases where Eskom has failed to provide for specific capacity on the network. Very importantly, it was felt under the planning space that the National Energy Act makes provision for an integrated energy plan. It's not clear as to when the next integrated energy plan will be produced, but at the same time, it's meant to have created that certainty in the market. And from there, we should have been looking at the development of the integrated resource plan, which, as you well know, is electricity specific. Now, of course, it does call into question the type of IRP as well that should be produced and the role of the municipalities in actually forming the background and the baseline for that particular IRP. One very important aspect is the notion of a sensible interpretation of that section. And the city has contended, in fact, that the current application of that section confers the role of super regulator onto the minister. And of course, that cannot be intended within the space that we operate in. And then lastly, as I mentioned to you before, there's the section 156 of the Constitution and roles and responsibilities under Schedule 4B that actually talk to the roles of the municipality in relation to providing energy services, amongst others, to its customers. And of course, the whole issue around the definition of reticulation would then come into play later on. Jack, if I could have the next slide. And then also just to note from that, stemming from that would be the respondents' arguments, and in particular NERSA's argument. And NERSA, as you know, feels that it's been constrained somewhat in terms of its powers because it has to wait for a ministerial determination to be made. Of course, we contend that it does not need to, but it maintains that it does have to. It's also common cause and not disputed by the city that NERSA and the Minister of Mineral Resources and Energy have the obligation to plan and oversee electricity provision generally. So we're not talking about operating in a vacuum. We're talking about operating within a centrally managed and controlled space from a planning perspective, as well as from an operations and control perspective. That talks to a national grid, which we then fit into, given of course that there will be certain flexibilities and allowances made to the municipalities in order for them to manage their own energy projections going forward. Another important consideration, of course, is that the regulator felt that our powers were limited. And of course, the issue around reticulation and particularly energy reticulation came into it. And the regulator felt very strongly, in fact, that the city does not have the right to actually generate its own power, which flies in the face of our Steenbras power station, our pump storage plant, as well as our own gas turbine technology, which is currently licensed for generation purposes. So really, there's enough evidence within our country of municipalities generating their own power to suggest that this is not to be it's not an accepted argument by any stretch of the imagination. If I can just turn to the next slide then, which really talks to the minister's argument. And the minister's argument in this case is that the city's case should not be entertained simply because of the Intergovernmental Relations Framework Act not being observed. Now, we've already mentioned at the outset that this does not apply in the case where NERSA is the other party in the dispute, nor is there a dispute with the minister, as I've said, for the reasons given before. The minister contends that the city should have applied to overturn a moratorium which was placed by the previous minister in terms of further Section 34 determinations. Also, it's felt that the court is not allowed to interfere in the business of government, and as I've mentioned to you, in part, the separation of powers doctrine. And this is why it was felt very strongly that we should have dealt with this outside of the legal process. And also they contend that the procurement of energy is not included under our constitutional powers. That, of course, does not make sense given the fact that we are allowed to purchase power from Eskom and any other source in respect of not only Schedule 4B, but in terms of the objective of being able to offer our customers the environmental benefits that come with that power that can only be derived from, of course, choosing an alternative to what is currently available. So thanks. If I could move on to the next slide. Just to touch on in terms of some of the comments following from that. So Judge Leonie Wendell actually reserved judgment. We're not quite sure how long it's going to take. It could be anything from 1 to 3 months. And of course, there are various options that might materialize in terms of the verdict. Just out of interest, it's important to note that both NERSA and the Minister did not offer any legal justification for the role of Eskom as the single buyer in terms of electricity, in terms of the current determination philosophy. That was never actually justified by the respondents. Also very important to note, of course, is that the regulations that were published a week before the hearing supposedly allow for municipalities to actually apply to purchase power as well as to generate additional capacity. Now, it has to be noted that the city was always in a position to apply. It's just that there's never been a response. So nothing much has fundamentally changed from the status quo before the court case. And we feel that is really just lip service in the face of the state president's SONA address, in which he alluded to the fact that municipalities would be empowered to generate their own power, in fact, stemming from that purchase power from independent sources. Also, based on another consideration is the determinations that were then published in draft. These were one is for emergency power, and the other one is for a mixture of renewable sources. And those were issued by the regulator as well in terms of public comment. It's not quite clear what they hope to achieve with those ones. I mean, we can have a discussion about it at the end of the session, but it doesn't impact specifically on the outcome of the court case at all. Thanks. If I can move on to the next slide. So this is now an area where we take you into what we consider, and Jack, if you could just move to the next one as well, where we take you through what our vision is for the city going forward. And I apologize if it's a slightly busy slide, but it's an important one, which I hope will be one of your take-home slides. It's important to understand that in terms of a diversified energy mix, one of the key considerations for us is a low carbon trajectory for the city. In order to get to that, we need, of course, to look at the generation side of it. And that generation will be made up of various sources. It includes the procurement of power from large IPPs. It also includes embedded generation. And for example, we have the small-scale embedded generation program that will be enhanced. It also looks at slightly larger small projects, such as in the range of 1 to 10 megawatts. And those could be city-owned, they could be privately owned. It could be an increase in terms of rooftop PV. But it could also be on the demand side, where we look, for example, at ramping up our energy efficiency measures within the city, talking specifically to our targets for net zero buildings, culminating, of course, in 2050, when we plan to obviously have carbon neutral, all buildings to be carbon neutral by that point in time. Along the way, we also have to consider smartening the grid in order for us to accommodate greater amounts of renewable energy onto our network, also catering for better communication systems in line with the growth in smart grid technology. And then lastly, and very importantly, of course, is to cater for those members of our community that suffer from energy poverty and also do not currently have access to sufficient and affordable quantities of electricity. So that really forms part and parcel of our energy mix in terms of our planning going forward. And as you would see from item number 1 on that list, the court case becomes central to that whole initiative. Thanks, Jack. If I could move on. So just to unpack some of that, obviously with the IPP program, a lot of that would obviously be dependent upon the court case. But already we have started our internal preparations for the establishment of our own IPP program. It's debatable, of course, whether that IPP program would be managed at the local level or would be incorporated into a national initiative for municipalities, and we'll talk about that in a second. But also very importantly to note is that for a national program, it will be primarily wind and solar based and also wheeled over Eskom's grid. So the rules and the processes and protocols around that have to be formalized and finalized still. And we're quite happy to have National Treasury CSP, the city support program, working with us to try and actually put a framework together for this. For the smaller scale projects and for this particular program, where the projects are less than 10 megawatts, the idea would be to connect them to our city grid. So those would probably not require much in the way of wheeling in terms of an ESCOM arrangement. Very important for us would, of course, under the MFMA, the Municipal Finance Management Act, these would obviously require a Section 33 approval. And this Section 33 approval really guides us in terms of being able to put contracts in place for longer than 3 years. The actual approval process might in fact be 18 months. We're hoping that National Treasury might consider a blanket approval process for qualifying municipalities, but this is a discussion that I think needs to happen and still be finalized. And then, of course, any PPAs around that will be signed subject to that section, to a Section 34 determination, if that is required, or the outcome of the court case, which might justify that it doesn't need one. Also, the wheeling facility, and some of you will be familiar with the fact that the city is developing a wheeling framework that will also allow a willing buyer, willing seller model to unfold, allowing us to get generators of power that are outside of our municipality to sell to our customers on our network, and of course to make the transparent charges available to parties to understand the modalities of how wheeling will work. Also very importantly is that we have set aside funding in Leila's area to increase the amount of rooftop PV and around the city, and this would be for public buildings, city-owned buildings. But of course, aligned to that would of course be the expansion of the current SSEG program, whereby we're hoping that we can introduce a model to further incentivize our residential customers and possibly commercial customers to take up a greater share of PV on their rooftops. Thanks. If I can have the next slide. Well, it hasn't changed yet on my side, Jack.
So we should be on the potential court case outcome slide.
Okay, so if it's not on there, it still says the city supply side programs. So I'm not sure if it's maybe just delayed on my side somewhat. That is quite possible. But I can, okay, so there we are. It's moved now. So in terms of the potential court case outcomes, there are a number of possibilities in terms of what the judge may decide. The first one is the first prayer that was asked for, in fact, is that the judge could rule that Section 34 is not required. Great, that means that the city can proceed as soon as it's able to in terms of its own internal processes. Or alternative approach is that the judge may deem the Section 34 to be legal, and then that is unconstitutional rather. And if it is unconstitutional and unlawful, then of course it means that we can still proceed as in the case of number one. In the third case, the judge may decide that the Section 34 approach is both legal and constitutional, in which case it's likely that the judge may ask that the minister review and provide an answer to the application that is before the minister at present. The other option is that the matter might be referred back to the three parties, and this of course has been the case for NERSA in its case, where ESCOM has been challenging NERSA with regards to the shortfall in the last tariff, MYPD tariff application. So in that example,
We seem to at least have lost
the matter was referred back to the parties. That is another possible outcome in this regard. Of course, there could be the option. Jack?
Sorry, we lost you there for a moment, Kadri, and it seems like you're back
Jack?
now.
Okay, apologies. All right, okay, I'm not sure where you lost me, but on this particular slide, let me just take you to the next slide because it really talks to the important steps that we would take based on which outcome does materialize. So if the court rules in favor of one or two, in other words, if it says that we don't need a Section 34 determination and it's unconstitutional, well, then we will progress as expediently as possible with respect to our plans for procurement of electricity. And the idea would be that it would be incorporating the grid connection issues that we might have with Eskom, but of course subject to any regulations that are enforced by the regulator going forward. I can move on to the next slide then. This is in the event that it's in favor of number 3, in which case there's a lot of uncertainty now attached to that, in particular around own generation, where we feel that if it's less than 10 megawatts, then yes, we might have some chances as well of being able to incorporate that onto the network as soon as possible. But of course, there would be big question marks around large and small IPPs until we hear from the minister, because obviously number 3 really puts the decision back in the hands of the minister, despite our efforts at this stage to lobby via National Treasury or to lobby the ministry directly. If I can move on to the next slide. So if the court application is dismissed, and then that means that effectively it's the current status quo as it is, which means we will continue with our embedded generation development subject to approvals as and when they do materialize. And I think that's the important consideration. However, we'll continue to work together with the CSP colleagues in National Treasury to ensure that there is a favorable allowance by the minister to just ensure that there is some space within the IRP to allow for the IPPs to come into play within the city. So that will still be a consideration of ours, but it does mean we will have to work within the confines of a nationally determined program at the behest and at the direction of the minister in this particular regard. Thanks. If I can move on to the next slide. So as I mentioned to you, there are other outcomes that are possible. For example, the judge might refer the matter back to embark on some form of mediation or settlement talks. And if this is the case, then we are quite open and amenable to having this discussion with the regulator. I think bearing in mind that there are other metropolitan municipalities, and I know that Paul Vermeulen is on the webinar from City Power, and I know that Paul and I share a similar view with respect to the type of landscape we would like to see emanating from such a process. And so we would happily engage with the other key stakeholders to ensure that there is a workable solution that meets the needs of all parties. And I think that's really the key issue. This is not about the city trying to go it on its own, which has often been the criticism leveled at the city by National. This is our attempt to actually put together a workable and a wholly sustainable solution that meets the needs of all stakeholders, both national as well as local, and of course incorporating the aspirations of the private sector in that space. Thanks. If I could have the next slide. So just in terms of some of the draft regulations that were published, if you can move on to the next slide, please. In terms of what it said, and I mean this should be common knowledge as well now in terms of those draft the amendments. The idea is that the integrated resource plan stays the predominant basis by which determinations must be made. A feasibility study, of course, is now required. There is no indication at this stage as to how long it will take to review that feasibility study. Municipalities must have a sound financial footing, such as City of Cape Town. And of course, any feasibility study that's produced must be aligned to the IDP of the municipality, which I think is also something that is, at this stage, it's quite easy to achieve. Very important to note that the minister may request additional information. This is quite vague. It doesn't give us an indication of why this might be required, how that information would be utilized, etc., and doesn't really take us further than where we were before. It's still apparent that a Section 34 determination will be required. It's still evident that the IRP must be followed in its strictest sense, despite the fact that the IRP has not been updated as frequently as it should be, nor is it dynamic enough to take into account the needs of the municipalities in its formulation. So to be honest with you, this does not change much, and I know the judge did ask about this in the pre-trial meeting, and of course it was made quite clear to the judge that in fact this amendment does not in fact do anything in respect of the court case as it stands. Thanks, Jack. If I can move on to the next slide. So in addition to the proposed amendments, there are some gaps in this proposed amendment, and I've touched on some of them. So even though the overarching feeling is of welcoming any progress, any steps that are taken by the minister, it also has to be noted that they don't take us sufficiently further than where we are at present. So at this stage, given our request in 2015, we feel that the amendments are not taking us forward, even though they might at the surface seem to be reasonable and accommodating of that request. So as I said to you, there are a number of these unknowns that are out there, and those unknowns cannot be answered through that particular amendment. So once we have some of the answers, I think we'll be in a better position to comment on how effective that amendment will be. I think they are listed for you some of the questions that we do have. The fact that the Section 34 determination remains in force, and once again, there's no timeline in respect of a response to such a request. The IRP I've mentioned to you, it's not dynamic, it's not responsive. Also, it's not clear where the determination will be made from. Is it the 500 megawatts that is set to come online after 2022, or will it be from technology allocations that we could already tap into? So that part, it's not clear. The other issue, of course, would be the additional information that I mentioned to you. It's very open-ended, does not give any indication of how that information is to be utilized. And also, there's no guidance on the limits per municipality, if any, or limits of technology, or the size or the scale of these technologies at all. So, as you can see, more questions than answers at this stage with respect to that particular proposed amendment. Thanks. If I could have the next question. Sorry, the next slide. Just in terms of also getting back to some of our processes, in terms of our own processes, we're proposing as the city that there should be a sustainable, credible program, a national one. I think this is the important consideration for today's session. It must be a national procurement program, but it takes into account the needs of the municipalities. It looks at the overarching demand nationally, but factors in the specific and localized requirements of the municipalities. Now, this is important not only for the municipalities, but I think also for investors and the IPPs out there that are looking at 5, 10, maybe even 20-year expansion programs into our country. And from an investment point of view, this is critical for our economy. Also, we're proposing that there should be a centrally run procurement process, which could be run through National Treasury. At some stage in the future, we'd be looking at establishing our own procurement office. But that has got a different focus in mind ultimately, which is more about the trading function, which a city will hope to implement at some stage. Also, very importantly, is that we feel that the program must be included under the existing IRP, but obviously with the notion that the IRP must be amended going forward. And the program should concentrate heavily on wind, PV, and storage, which would be our primary considerations, but obviously other municipalities would be free to input into that as well. And of course, along the way, and this is what the benefits of centralizing that would be, that you'd end up with standardized processes and contracts that could be adopted. For example, I mentioned to you earlier that National Treasury could look at some blanket approval for Section 33 contracts that meet certain criteria up front, and those would make it quite easy for us to enter into those contracts within a short enough period of time. For municipalities, of course, compliance with the MFMA is critical, and of course this has to be factored into any of these processes. We would anticipate that any of the IPPs would also require licensing and permits as per normal, and that could be done through the national REIPP program. One of the key areas of consideration is what happens from a perspective of socioeconomic development. And the idea is, do we compensate for that as is the case of nationals programs, or do we in fact look at giving value for money to our customers directly, rather than actually creating projects in certain specified communities, etc. The idea would be that we'd like to pass on the savings and benefits to all residents, rather than just to specified project targets in this particular case. Thanks, Jack. If I can have the next slide. So there are some additional unknowns, and I won't unpack all of those unknowns for you right now. I think they're quite obvious in respect of questions that we have, but it is quite critical. In the event that we put a program like this together, there are issues around grid reinforcement, and those costs have to be carried by someone. And that will impact on tariff setting, whether it be for the city's procurement or whether it'll be Eskom's tariff, but there will be issues. Also, things like time of use link criteria. How will we be allowed to generate and then to actually sell electricity to other municipalities? And how does Eskom, in the process of supporting this, recover its costs if it keeps on losing sales to municipalities? So all of these considerations have to be taken into account. Also, from a balancing point of view on the network, the issue is around emergency supplies as well as added peaking generation. The question is, who's going to be responsible for that and how they compensated for making up the peaking generation based on the fact that renewable energies, of course, are intermittent in nature. So that balancing has to take place to ensure that we have an adequate and reliable supply of electricity on the network. So there are some questions regarding individual limitations with respect to municipalities, the allocations themselves. I've mentioned to that before. And we have the same questions around capacity constraints per municipality or per project size. So it's really just a question of how will that be determined? We don't know that, but ultimately these are the type of things that we're trying to resolve with national at the moment. Next slide, please. So there's also another busy slide, but it's meant to give you an indication of the timeline for us to implement a large-scale IPP program. So don't be too discouraged by a 5-year timeline. I think just look at the underlying criteria that has to be met and the compliance issues that exist within the municipal framework, and you get an appreciation, I think, of why you see such a timeline. So in fact, the first year, which we're currently in, is really just about setting up the internal processes. And of course, that will have to make sure that it's aligned to our integrated development plan, linked to our budget framework, and then also to make sure that we do have a municipal renewable energy IPP program that can be launched officially. And that, of course, will be done in the aftermath of the court case, depending on the way that the court case unfolds. And then obviously moving forward from there, after we've done a lot of internal work, is obviously looking now at the nature of the relationship, the structured agreements and contracts that exist with the IPPs, as well as the technical aspect that looks really at good integration issues, as well as socioeconomic requirements. And then post that, of course, we'd be looking at in year 3 at the actual tender processes, putting it out to the public, and then from there being able to work very carefully around the evaluation processes, as well as making sure that all the conditions precedent are met. If we're able to do that, then I could see that in line with this process, that by year 5, we'd be in a position to ensure that we're ready to procure that power and actually make sure that power can be commissioned as soon as it's practically ready. So this is more an indicative framework for you of what the process looks like. Leila in particular can answer some more questions around the actual details on this, but it is an important slide for you. And just to end off with an important consideration as well is that we need the IPPs to register as vendors on our network. So I'm going to appeal to you after this to please follow the link and to try and register. If you haven't already registered as a vendor, to please go and register yourself, because this will be one of the key processes that you're going to have to comply with in order to be considered as a vendor going forward. So please do that. I've tried to run through a lot of the slides with the intention to leave some time for discussion and questions that might arise. As you can see from the presentation, there are a number of uncertainties that we face. There's a number of key developments that are taking place right now, which are comforting as well. It does mean that we should have a nationally supported program. I'm talking particularly about National Treasury right now, of being able to support us in this process going forward. We're hopeful, of course, that the other municipalities supported by SALGA will also come to the table as they have expressed their support in the past to craft this particular framework going forward. So I think it's with that in mind that I'll leave it there, but I think the important consideration for us is that we don't intend going this on our own. We fully intend that this is going to be a multi-stakeholder process. Yes, we have a very strong vested interest in the outcome of the court case, but at the same time, we believe that it's in the national interest that we develop this framework as a matter of urgency, and as such, put together a low carbon plan for not only the city of Cape Town, but I think all the cities that make up South Africa. So on that note, thank you very much for your attention.
Brilliant. Thank you so much, Kadri. I think that was a very good presentation that covered quite a lot of ground in a relatively short time. Can I ask our other panelists just to jump back on? I see we have Leila back and Sue as well. So we do have a little bit of time for questions, so I'll take 1 or 2 of them. Maybe Leila, starting off on your side, there have been a couple of questions around the city's appetite for liquid natural gas, as well as whether something's been explored on a sort of PPA approach with gas-fired stations.
Thank you, Jack. That is an interesting question. While our focus is primarily on renewables, um, I think some of the audience members will remember that we had a 2-year study on LNG and LPG funded by USAID. And those studies suggest that LPG and LNG is not economically feasible right now. Um, there's the, yeah, that it's quite a detailed study. So it's not a priority of the city right now to pursue LNG or LPG. The other two considerations would be that by 2050, as Kadri said, we'd like to be carbon neutral. So any plant that is set up in this period would need to consider that target and what it means for them. And then, of course, price would be an issue. As I said, the study suggests that coal could even be cheaper than LNG if it was imported into Cape Town right now. And all the projects, if we get to that stage, would need to be below Eskom Megaflex. And if it can't meet that, or at the same rate as Eskom Megaflex, and if it can't meet that price target, then it won't be viable for the city.
Brilliant. Thank you so much, Leila. I think there's been quite a few questions also around, as Country mentioned, the space for the municipality within the IRP. I think that's still yet to be answered, as you'd indicated, whether that's going to come from the technology allocations or from this sort of unallocated piece. One of the questions that keep popping up is the rationale behind the 10 megawatt threshold between the sort of small scale or the distributed generation and the larger scale program. I don't know if anybody wants to weigh in on that.
We decided to have a small scale program below 10 megawatts because those sort of projects would be, excuse me, easier to connect into our distribution grid. So we're being a bit bold. We are developing a small scale program. We would still require an outcome from the court or a stance on the Section 34 determination. But it is a program that would be more manageable for the city. We do not need all the other authorities to provide context and information and approval. It's something that we would be able to connect into our substations, hopefully quite easily. Thank you.
Right. So, Kadri, you mentioned the new generation regulations that were released just before, or the amendment that was released just before the court case. One of the questions that keep coming up is that mentioned the municipality's requirement to be a going concern, which is understandable, but there wasn't any mentions around guarantees. Is it the intent to continue without guarantees? And if so, do you think there'll be investor appetites to proceed without those guarantees?
I think all along the expectation was that this would be a program run together with National Treasury. And of course, when one considers the notion of good financial standing, the expectation is that National Treasury would support the underwriting of that liability going forward. So from our perspective, we wouldn't anticipate that we would be going that on our own. We'd anticipate very strongly that National Treasury would be on board in that process. Look, we don't anticipate that too much will change from a financial position in any event. First of all, the cost of new renewable energy for us, we anticipate that it will be reasonable. It will be very close, or should be very close to the current bulk prices that we pay from Eskom. And of course, that's based on Megaflex, as you know. So we don't anticipate that it's going to be drastically different. And as long as we are able to show National Treasury that we have a funding plan for the duration of the PPA, I can't anticipate that there would be too many problems with them underwriting that debt going forward. Thanks.
Leila, you want to add something?
Maybe just to add that the initial discussions with National Treasury, they've been scanning the IPP sector, and from their perspective, they suggested that perhaps these IPPs would be very happy with the credit rating of the city and would not necessarily require a national guarantee, a sovereign guarantee. Thanks.
Great. And maybe looking from a slightly different angle, there's been some questions around the city's appetite to develop and permit their own renewable energy facilities, or looking at the sort of IPP approach.
So maybe I'll come in, and Leila, if you'd like to add on as well, please do so. I think, first of all, there is appetite on our part to operate a certain number of specific projects as the city. We're currently investigating the feasibility of between 1 to 4 solar plants, ground-mounted solar plants, and that could possibly be up to 10 megawatts each plant on each site. And we're still busy with the feasibility on that. Beyond that, we're not anticipating too many other plants. Some of our colleagues in solid waste, for example, might opt to build more waste to energy plants. There is, of course, the notion that there would be some power being generated at the coastal landfill site. We're not preempting that this will happen. We're just saying that it is not a major focus of ours at the moment. Our focus has really been about opening up the market, and of course that means a greater share of that to the IPPs. Lily, if you'd like to add to that.
Just in terms of timeframes, we released a tender in February for consulting services to support the development of our own plant, the development of our own plants. It was, for example, environmental services, geotech services, and those sort of assessments. So I think it's nicely on track. That will be one of the options available to us if all the other options close down. Obviously, it will be small compared to what our overall target is and our intentions, long-term intentions, and therefore the IPP bulk program is really key. And we really need support in getting that approved and off the ground. Thanks.
Great. Sue, there's been quite a lot of noise in the media around the minister's sort of response to the case and his intention to continue. Could you give some comments on that in terms of what Kadri had said, that this case is really with the independent, with NERSA essentially, and not with the minister himself?
Yes, the case is, it cited both the minister and NERSA as respondents, but ultimately NERSA is the regulator, and that is why Kadri made the comment that, and that is why we cited NERSA as a first respondent. The two, there's an interplay obviously between the two. There's no question that licensing is required, and that's NERSA's competence. There are questions around the Section 34 determination. That is, that again explains why NERSA was our first respondent and the minister the second respondent. I hope that answers the question.
Yeah, thank you. I think that's great. So I think there is a really interesting question, and this really speaks to a wider challenge within the renewable space. And Kadri, I know you mentioned that the city really sees this as being run from a central sort of procurement space. But there have been a couple of questions around the ability of city to sort of make their own land available to projects, and taking sort of that approach to looking for new projects, or rather much like the traditional REIT model, asking IPPs to come with the full package. I don't know if you want to give some thoughts as to those two different models and sort of the impact of it.
I'm not sure. Leila, do you want to go first? I mean, I can.
Yeah, yes. So for the small scale projects, the below 10 megawatt, there is obviously an option for city land, but that would be a separate arrangement that the developer would need to secure prior to submitting their bid. In terms of the national, if there were to be a national program, projects can be located anywhere. The price, or whatever the criteria is that will be the defining factor, will define which project comes online. So, for example, a PV plant could be located in the Northern Cape and provide energy to either City of Joburg or Cape Town. But that is why we need a national program to coordinate this and to have the most efficient system for all cities, for all municipalities. Kadri, do you want to add anything?
Yeah, I don't think I'd be doing you any justice if I added to that. Maybe just to note something else, and that is that there are obviously tracts of land in the City of Cape Town that could be utilized for this purpose. It might be premature for us to go into details on that today. So we would welcome that. I think along with that, we'd also welcome local content. And because of that, we're working very closely with our colleagues in the Economic Opportunities and Asset Management Directorate, looking at how best to actually stimulate local economic development that comes with this. So that should also be seen as a key driver for us, particularly around the smaller embedded generation projects. Obviously, for large-scale IPPs, one can anticipate they won't be located within Cape Town. And of course, that means that the lion's share of the economic development might take place outside of our jurisdiction. So it's also with that consideration in mind that we'd be looking at supporting these smaller projects as much as we can. One of the areas that we are looking at is the old Athlone Power Station, and actually getting permission from council to actually reconsider its use in the energy space, because that is obviously an ideal site. It was zoned for that previously and could be utilized given the access to natural resources in the area, such as waste, solid waste, as well as the wastewater treatment plant, etc. So there's a good resource that's sitting out there, which we'd like to see some form of partnership with the private sector, but probably a bit early to go into any more details, other than to say that the city would really welcome the opportunity to work with the private sector in ensuring that development takes place within the metropolitan area.
Brilliant, thank you so much for that. I think we'll take one more question, and then I'll let each of the panelists just give a final closing remark, and we'll pretty much be out of time. So there are quite a lot of questions. Kadri, you mentioned the concept of becoming a trader, and there are quite a lot of questions around starting to move away from a sort of megaflex MYPD pricing methodology, more to a space where there's sort of a market type approach. Is this something the city is really looking at for the longer term role of the municipality?
Oh, absolutely, Jack. I would stress the longer term element of that. I think for now the issue is just to unpack the regulatory requirements that allow us to procure power. That's of course the first step in this whole process. After that, once the market is more open and competitive, I think certainly the rationale for trading will be there. The whole notion around green certificates, of course, will come into play. There are a number of customers that have expressed an interest already in green certificates. Also, we can obviously act as a trading function for only distributing power beyond the metropolitan area, but also in terms of being able to create a platform for the growth and development from a manufacturing point of view. So that will go hand in hand, in essence, with a pure trading function. So all of that is possible in the longer term, and something that the city would like to maintain a focus on. This is why I said the notion around the IPP office. We would support the notion that it should be driven nationally, particularly at the outset, but that it should eventually also make some space for a localized office that fulfills the trading function, and then also looks, of course, at the procurement, the bulk procurement under the current framework as well.
Brilliant, thank you so much. So maybe any closing remarks from the panels before we close off? Maybe starting with yourself, Leila.
Maybe just to say that an important leg of our carbon neutral, our climate goals, as well as our energy security goals, is dependent on securing bulk procurement of renewable energy. And we are not going to tread lightly or back away from challenging the existing system to try and get us there. It's something that every city needs to be thinking about, and I think that the current proposed amendments to the regulations acknowledges the role that cities should be or could be playing in the energy sector. And I hope that everybody online can get their comments in and make sure that the role is amplified and clarified, so that because the change is going to come from the cities, so I hope that they get their comments in to encourage the national department to go this route. Thanks,
Awesome.
and thank you very much to GreenCape for arranging the seminar where we could share our ideas. Thank you.
Great, thank you so much. And Sue, any last one from your side? We haven't delved too much into the complicated legal side of things, but
no, just one comment, just to note that the court case was heard in the North Gauteng High Court. But if the judgment is unfavorable, it's not necessarily the end of the matter. Like any High Court matter, it can proceed to higher courts, to the Supreme Court of Appeal, and even the Constitutional Court. So we may have a longer term fight on our hands, depending on who wins and who loses, and how the unsuccessful party takes the defeat. It could be a while. So obviously the work that we're doing, the preparatory work that we're doing to move towards a sustainable renewable energy procurement system is very important. That must continue, but it could be a while before we have a definitive legal outcome.
Great, thank you. And it's great to see the city continuing to move forward and really push this. Kadri, from your side, any final closing thoughts?
Yes, thank you, Jack. Firstly, just to thank those attendees, I think, that have joined us today and particularly prompted us with some very good questions. And I note that there's a lot of interest in this matter, as I said, locally and nationally at the same time. Maybe just to also touch on one subject which we haven't really touched on, which is what happens to Eskom in the event that the city is successful. I think it's our belief, and maybe from one or two of the other metropolitan councils, that it does not mean the end of Eskom. Certainly for us, there's no way that we could purchase 100% of our power requirements from renewables at this stage, not with the grid being the way it's structured at the moment. So certainly there's an expectation on our part that we would continue to, in particular, support the purchase of baseload capacity from Eskom, subject to certain conditions being met, which would have to be fleshed out in the form of a service delivery agreement. So that still has to be resolved. But it does mean that it does make space, obviously, for IPPs in the market without shutting Eskom out completely. And I think given the liabilities that Eskom sit with and the national implication, I think it's also important that we give some comfort to those stakeholders in government that obviously are concerned about Eskom's viability going forward. So I thought I'd just end with that as well, to note that, you know, it is a consideration of ours, and we do try and take into consideration all stakeholders' inputs. And lastly, just to thank you as well, Jack, for your facilitation today. Thank you for an excellent job, and thank you also to GreenCape for hosting this important event for us as well. Thank you.
Brilliant. Thank you so much, firstly, to all of our panel members. We really appreciate your time. It's great to be able to see everybody's faces, even under these strange circumstances. I think the comments and final questions here are all coming in with a resounding thank you from industry for a very informative and well put together presentation. So I think the feeling there is that it's been a great time together. So thank you so much to our panelists. For everyone still listening as attendees, the session has been recorded, so it will be made available with the slides. As Leila mentioned, the new generation regulations are out for public comment, so please do get your comments in to make sure that the minister hears the voice of industry. And we're looking forward to seeing everybody under hopefully slightly different circumstances the next time we meet. I hope everyone has a lovely week further. And once again, thank you to our panelists, and everyone keep well and keep safe. Thank you.
Thank you.